Good morning. I'm going to pick up where I left off with the Amendments 1 through 5 lecture. Just to remind students that Amendment 5 has these five different protections. The big one is the fair and equal treatment under the law, the due process. And remember, Amendment 5 is for the federal due process. Double jeopardy, self-incrimination. You don't have to testify or provide information that would incriminate yourself. The grand jury, again, I apologize that the Law and Order that I was trying to record yesterday to show you a grand jury didn't work as well as I'd hoped to, and that the eminent domain is the government's ability to take private property for public use. Moving forward, we'll get into the requirements of a jury trial. Now, the requirements of a jury trial, these are things that are going to take place in a courtroom. So if we're looking at what takes place once you've been formally accused, this is the stuff that you're going to find in Amendment 6. So the first part of Amendment 6 says that you are entitled to a speedy and public trial, meaning that within reason, the government can't just take you into custody and hold you for years before you're even given a chance to appear in court. You will also be given a jury trial. That's a big deal in that it's not just a single judge that's going to rule on your verdict. It is a group of your peers that are going to make the decision of whether or not you are guilty or not guilty. Third part of the right to a jury trial is the right to know your charges. Sometimes we'll refer to this, or often we refer to this as your arraignment. You're not there without knowing why. And we talked about this in Article 1, Section 9, when we talked about the government's inability to hold you without reasoning, and we referred to that as the habeas corpus, but Sixth Amendment brings it up once again. And keeping in mind the requirements for the jury trial up here is the federal level. This is not going to change until we get into the 14th Amendment, where due process is then extended to the state level. So continuing on, the right to a speedy public trial by a jury of your peers. You have the right to know your charges. Additionally, you have the right to have a defense, meaning that it's not just the prosecution. Your side is given an opportunity to speak and to question the evidence and the witnesses brought forward by the prosecution. Very different than a grand jury, because in the grand jury, all you see is the prosecution, but when you get into the trial, the accused has the right to defend themselves. Additionally, the accused will have the right to confront witnesses, not necessarily meaning that they're going to be given the right to actually the accused ask questions of the witnesses, but through their defense, they will be able to cross-examine witnesses and challenge evidence as well. And then the final one that's a big deal in the Sixth Amendment is the right to counsel. The right to have legal representation there for you. For a long time, counsel was only at the federal level, and it was in the 1930s that in a case known as Powell versus Alabama. Powell versus Alabama was a case about a group of kids in the 1930s who were riding on a train car, and there were groups of white kids and African American kids, and a couple of the white boys got thrown off the train, and so they went to the local authorities, and they told the local authorities that they had just been beat up by a group of black kids on the train, and that in fact a couple of the young boys young black boys had raped a few of the white girls. And so by the time they reached the next stop, police were there and they took these boys off the train and they threw them in jail, and they were facing the death penalty in Alabama. And so, long story short, they ended up being found guilty. And then in an appeal, some attorneys did step forward and represent them in an appeal. And long story short, gets to the Supreme Court, and the Supreme Court makes the decision that if you're ever going to face the death penalty, you need to have legal representation, even at a state level. And that held to be the case through the 1940s. And then there was a case that came forward, Betts versus Brady, which said that if you are facing, you have to have state representation if you are homeless, if you are in poverty, if you are mentally ill, which kind of extended the idea of the Alabama case. But it wasn't until the early 60s that we ended up with public defenders because of one guy who, in Florida, he was arrested in Florida for breaking and entering into a pool hall, and he ends up conducting his own trial on breaking and entering and theft. And he tries to represent himself, but he's found guilty and he's put in prison for several years. While he's in prison, he starts to read up. He really believes that the Constitution says he has the right to legal representation. And so he writes a letter to the Supreme Court, and some odd, miraculous way, this case got actually heard by the court. And the Supreme Court ruled unanimously that in state cases, anytime a person may face incarceration, whether it be house arrest, jail time, prison, and they can't afford a representative, they will be provided one by the state. And so since that point now, counsel is required for any person who faces incarceration. So one man making a decision in the late 1950s, early 1960s, and writes this letter to the Supreme Court, he ends up literally changing the way the public defense system is set up even today. So if you look at all 6 of these points of what's required in a jury trial, you're going to notice that every one of them actually does take place in the courtroom. Going to Amendment 7, we're talking about the rights of somebody who is involved in a civil trial, and a civil trial is a lawsuit. So when we look at lawsuits, there is protection also in the Constitution that if we sue somebody, we have the ability to have a jury as well. The unique thing about Amendment 7 in 1791 is that this actually talked about disputes that were fighting over $20 or more. If there was a lawsuit where the challenge involved money more than $20, then the person who was being sued has the right to a jury trial versus just a judge making the decision over whether or not a person is liable when being sued. So we really don't pay much attention to this one anymore because $20 is so insignificant when we consider what it was worth in 1791. We get to the 8th Amendment and we start to look at the fines and punishments. And so the first thing in the 8th Amendment that we take a look at is that we are the state, and originally it was dealing with the federal government, but that we are protected against excessive fines and bails, meaning that if you are arrested and you are facing a fine or you're facing a bail, it is legitimate taking into consideration what is the crime, what is the potential to affecting the public, what is the economic background of the person being accused. I mean, there are times where judges will actually revoke bail and will remand a person into custody. And A lot of it has to do with safety to themselves, others, or the public. That can be done. But excessive fines is just being kind of connected to the community. I mean, saying that you get a $10,000 fine for speeding in a school zone would be challenged immediately. And then the big part of the Eighth Amendment that most people are interested in is understanding that what the idea of cruel and unusual punishment is. Now, there's lots of stuff out there on what we consider cruel and unusual. But I'm going to quickly just flip over to a video for you just to see where we are in the United States as far as our death penalty goes in the United States. So just hold tight. I'm hoping this works this time better than the one I did last time. So if we can get this to move over to there, and hopefully it will record a little bit better than the last one did. There are truly quite a few good videos out there explaining the death penalty. I know they said that they had some legal forms of execution still in the United States is hanging and the gas chamber and the firing squad. Part of the reason that those are still legal options for execution is because the states have never created laws that eliminate those forms. Lethal injection is the form that's used in all the states that still have the death penalty. But the other forms, a lot of them are still applicable if you were convicted before a certain date. Otherwise, the execution form of execution is by lethal injection. All right, moving on to the last two amendments in the Bill of Rights. These are very vague amendments, and Madison specifically wrote these because he knew that there were things that people wanted protection of, but wasn't able to actually pinpoint what specifically the protections were. So he was kind of vague in what he decided and what he wrote down. So the Ninth Amendment is about protecting the people and basically saying if there are things that people want individual protections on, then if it's not listed in the document, the powers still belong to the people. And what we've come to understand with the Ninth Amendment is we're talking about the right to work, the right to marry, the right to education, as just a few examples of items that Madison wouldn't have considered at the time, but that these rights are still out there. Another one is the right to die. We're talking about the death with dignity laws. but that ties really in conjunction with the 10th Amendment. And basically what the 10th Amendment is saying is that any right or any power not delegated, oops, boy, am I having trouble today, not delegated to the federal government, whether it be the president or Congress, if it's not delegated to the federal level, the power is reserved. And that's where we get the idea of our reserve power. The power is reserved to the states. So if it's not listed in, for example, Article 1, Section 8, and that's the powers of Congress, if it's not listed there, or prohibited in Article 1, Section 9, as we've gone through those, if it's not listed in one of those, it is essentially a power that is given to the states. And when we go through federalism, which we'll definitely get through in the next, once we finish up this chapter and get through chapter 1 through 3 exam, then I'm going to go more specifically through the delegated, or what are the powers of the states, and how we can see that if it wasn't directly given to the federal government, it actually is reserved, and the states still have that power. So with that, I'm just going to end this lecture on amendments 6 through 10, hopefully giving us a little bit more information on what the Bill of Rights is, and how all these components start to work together. The next lecture I'll do is on the remainder of the amendments 11 through 27. So, well, until then.